Jeffrey Schwartz from the Thomas M. Cooley Law School joining us now. Jeff, I got to ask you, how do you defend shooting anyone over a text?
You can't defend shooting someone over a text in this particular instance. Something set this man off. And as a defense attorney, I think I would probably start looking at the mental health of the person who is the defendant in this case.
And so age may play in, perhaps dementia?
Well, I wouldn't say age, because we don't want to look at it as an age discrimination type of manner, but obviously at this age and with his past, it's hard to believe that this guy got set off by just such a simple matter. And in fact, based upon the testimony that I heard from today, it seems that this has happened once before, but without the violence.
Yeah, so what's the standard? If he is sort of setting up a defense that I felt threatened because the popcorn started flying, what's the standard? That it was something that a reasonable person would feel could be threatening?
Stand your ground says that you have to reasonably believe that you are in serious danger of great bodily harm or death. If we have popcorn flying, I doubt seriously that popcorn is going to cause serious harm or great bodily harm or death to the person that is in this case, the victim.
So if you're looking at mental health issues, would you have to then establish a pattern as a defense attorney, that this is not just a one-time thing? Because that would be...
That would in essence be a form of temporary insanity, which we don't permit in Florida. So you would have to show, if you're going to use a mental health issue, you're talking about dementia, that is a reduction in his ability to understand the consequences of his act, to know the difference between right and wrong, or formulate the necessary intent to commit the act.
Now, based on what the attorney for Mr. Reeves said after during a brief comment to the press today, they seem to be setting up this defense that he is a sterling citizen, that he's a great guy, that he was really integral with the Tampa Police Department in setting up their SWAT program. So it's almost a character defense. Do you think they're going to continue with that?
Yeah, I don't think you can go there. It's irrelevant to the matter of whether he is guilty or innocent of the offense for which he's charged. Unless the state makes his character an issue, this is just not going to be relevant at the trial.
And on the other hand, they might be trying to vilify the victim here, indicating that that he was sort of the aggressor here, that he may have been the person that knocked the popcorn over. He's not here to defend himself, so how important are those witnesses going to be in the movie theater?
Well, the witnesses are going to be important to establish whether there was really an angry exchange between the two, to establish whether there was an increasing volume going on. To the same extent, the mere fact that popcorn got spilled, I don't think is irrelevant. Somewhere, in order to defend him on stand your ground, which I don't think I see in the evidence so far, there's going to have to be some sort of threat that is coming, that is imminent, that it's going to occur.
All right, Attorney Jeff Schwartz from the Thomas M. Cooley Law School, thank you so much for joining us.
My pleasure.
And